May I please the court?
You may.
The defense moves to suppress Exhibit 4 taillight fragment that the Commonwealth intends to introduce at trial. Under Federal Rules of Evidence 901, the Commonwealth must authenticate physical evidence by demonstrating that it is what they say it is. Here, the prosecution cannot make that showing because the chain of custody for these fragments is impossible to repair. First, the fragments were allegedly discovered on multiple different days by different officers in locations that were not documented consistently. Some fragments appear only after substantial disturbance to the scene. That alone creates a reasonable likelihood that misidentification or contamination. Second, the documentation is incomplete. There is no existing photographs of the fragments exactly as they were found. There are inconsistent descriptions regarding size, number, and location. Collection logs are incomplete, and the chain of custody form contains gaps where no officer signed off or where the custody is unclear. Third, the Commonwealth cannot establish who had the fragments between initial recovery and their submission to the lab. There are period hours in some cases where no officer can testify where the evidence was kept, who had it, or where it was secured. 901 of the Federal Rules of Evidence requires proof of identity, integrity, and undisruption, but the prosecution fails to provide this. The risk of substitution, contamination, or loss is genuine. Due to unreliable authentication, we ask these taillight fragments are excluded.
Thank you. Commonwealth?
Your Honor, the Commonwealth disagrees that any misconduct has taken place which may taint the legal system or infringe upon the defendant's right to a fair trial. The dismissal of evidence is warranted only in cases of intentional and egregious misconduct, which has not been demonstrated in this case. All officers involved in this investigation acted within their duties as agents of the law to substantially collect evidence from the scene of the crime committed. To the first point brought up by the defense, while law enforcement agencies were tasked with the duty of preserving evidence, which therefore extends to timeliness in pursuit of this preservation, they must also be expected to work within their pre-existing operational functions. There cannot be an expectation from the defense that under the conditions of the scene at the time of the offense, fragmentary evidence would be found immediately after the act was committed. The defense's motion does not accept that in the early morning hours of January 29, 2022, there was extreme inclement weather in the Canton, Massachusetts area, which caused the scene to be covered in snow and frost that would have to be disturbed to find evidence that would have appeared in the hours that the crime was committed. Relating to the second and third points brought by the defense, the Commonwealth offers up the reasoning that common errors may be admissible in court when made in the process of obtaining evidence in good faith. Law enforcement on that night was attempting to obtain as much evidence as they could given the circumstances of the scene. All actions during the investigation were in good faith. Under the Federal Rules of Evidence number 901, any evidence introduced must be authenticated and proven to be in substantially the same condition as when it was collected. All relevant evidence has been disclosed and is in substantially the same condition as when it was collected, and therefore the defendant's motion to suppress this evidence should be denied.
Motion to suppress is denied for unfounded reasoning from the defense and the lack of ability to sustain the integrity of their statements. The evidence that has been presented does not display a competent line of reasoning establish any other verdict.